So I have an important update for you in one of the major pistol brace challenges and the current nationwide block on that ATF rule. So let's break down what is happening. Now, before we jump into this video, I want to thank the sponsor of this video, which is Manscaped. I think we need to talk about some holiday gift ideas, and whether it's for you or for someone special, Manscaped has the ultimate grooming package with their Performance Package 5.0 Ultra. This isn't just any grooming kit with tools like the new Lawnmower 5.0 Ultra for a smooth trim or the Crop Preserver deodorant, which actually helps you keep fresh. This package has everything you need to stay sharp, comfortable, and confident. Plus, it even includes post-shave care to leave you feeling like $1,000,000. Whether you're treating yourself or shopping for someone else, this is the ultimate way to level up your grooming game this holiday season. And here's the best part right now for my channel viewers, you can get 20% off plus free international shipping when you use the promo code ARMSCHOLAR at manscaped.com. So if you're looking for a holiday gift for yourself or someone else, I highly recommend Manscaped. Head over to manscaped.com/ARMSCHOLAR to snag the deal and to also wrap up any holiday shopping that you might need. As I mentioned in the intro, in this video, we will be discussing another huge win against the ATF and their attempt to expand the definition of SBRs. The 8th Circuit Court of Appeals recently ruled that the pistol brace rule is invalid because of the two-step analysis that was used by the ATF to determine if something is an SBR, if something that has a brace on it is an SBR. That two-step process that the ATF is engaging in is in fact arbitrary and capricious. The 8th Circuit found that the ATF not defining what qualifies as rear surface area and then also not qualifying and defining what market practices are, that means that this rule must be struck down in its entirety. The plaintiffs in this lawsuit are now asking for the entire case to be held and ultimately tied with another case and an upcoming ruling in the 5th Circuit in the Mock versus Garland case. And that case involves a nationwide block and vacatur of the pistol brace rule. Now, in this case, FRAC, which is a two-way organization, along with SB Tactical, one of the largest producers of pistol braces, and then also 25 states sued the ATF in North Dakota. In this case, the district court originally denied the plaintiff's request for a preliminary injunction. The plaintiffs then appealed that denial up to the 8th Circuit Court of Appeals. And recently, a 3-judge panel in the 8th Circuit ruled and found that the preliminary injunction should have been granted by the lower court because there was a likelihood of success on the merits of this case. The 8th Circuit found that the pistol brace rule is arbitrary and capricious in its application and therefore violates the APA. Now, in the FRAC case, the 8th Circuit found that the ATF rule on pistol braces is in fact invalid, that it violated the APA, but they came to it by a different conclusion, ultimately the same result, but there was a different analysis based on the APA. First and foremost, the 8th Circuit found that there was a big issue with the two-step process that the ATF created, which determines whether or not a firearm with a pistol brace on it is actually an SBR. The ATF first focuses on whether or not there is rear surface area that can be shouldered, and then the second thing that they look at is whether or not there is a marketing and community standard that treats these types of attachments as intended to be shouldered. In the opinion, the 8th Circuit stated that the coalition alleges this step is arbitrary and capricious because the ATF refused to include more specific metrics on the minimum surface area required for shouldering. We agree with the coalition. The ATF has articulated no standard whatsoever for determining when a stabilizing brace's rear surface area would allow the shouldering of a weapon. That the regulated parties wish to see more specific metrics does not mean that they wish to skirt or circumvent the law, as the ATF insinuates. They may simply wish to comply with the law by producing or equipping stabilizing braces that do not have rear surface area that allows for shouldering firing of a weapon. So the 8th Circuit found that the vague standard used by the ATF talking about rear surface area that could be shouldered, but providing no metrics or no additional information on what qualifies as rear surface area, that was a violation of the APA. They then also found a major issue with some of the vague community use and marketing standards. One of the big issues with the 8th Circuit and what they found with this process is the fact that the ATF is trying to attribute third-party conduct and intent to a specific individual. So just because someone else would use a pistol brace a certain way, maybe shoulder it, does not mean that that's the way that the product was intended to be used. And that doesn't mean that's how you as an individual will use that. And based on that, they found that the plaintiffs here, FRAC, were likely to succeed on the merits of their arguments because this did violate the APA. The frack case challenged the new ATF rule, but there were other challenges that are currently going on and were brought up, like the Mock versus Garland case. And in that case, Judge Reed O'Connor in a federal district court in Texas issued a final merits decision, which ultimately vacated the pistol brace rule in its entirety nationwide. And that is what's currently protecting everyone nationwide with their braced pistols. He also found that the ATF violated the APA because the final rule was not a logical outgrowth from the proposed rule, and that was one of the main bases that he used to strike down the ATF rule. Now, the Mock case was recently appealed to the Fifth Circuit, and oral arguments are pending in that case, and that's important for what has now been found in the Eighth Circuit case, the frack lawsuit. The plaintiffs in the frack case have now decided to directly tie their lawsuit in their case to the pending arguments and the hearing that are set in the Fifth Circuit Mock case. Essentially, what they are arguing is that the Eighth Circuit should stay this case because if the Fifth Circuit rules against the ATF in Mock and upholds the nationwide vacatur of this rule, and again, that would be applying nationwide, that would mean now that the Eighth Circuit lawsuit is moot and the case could be dismissed in favor of frack. And again, that would lead to a domino effect where you would get a win in the Fifth Circuit, and then you would get a win also in the jurisdiction of the Eighth Circuit, and the district court would have to rule in favor of the frack plaintiffs. Interestingly, the ATF opposed that request to stay the case because they wanted this case to proceed forward even though they keep suffering a loss after loss. They wanted this to move forward because they don't want the two cases tied together. They wanted them separate because they want to be able to lose in the Fifth Circuit, which they likely will lose in the Fifth Circuit, but they don't want that loss in the Fifth Circuit to result in an ultimate loss also out of the Eighth Circuit. In their opposition to the stay, the ATF argued that although a single district court in another circuit has entered an order to vacate the rule nationwide, that order is not binding on this court and will not necessarily overtake plaintiffs' claims in this case, particularly because the court's merits analysis focused in part on the illogical outgrowth claim, a claim not presented in this action. So the ATF conceded that the Mock decision found that the brace rule violated the APA, and that ruling resulted in a nationwide vacatur of the rule. So the ATF, for the first time, is conceding that there is a nationwide vacatur of this rule. They argue, however, that the Mock decision was based on the logical outgrowth analysis and not the arbitrary and capricious standard. But what the ATF fails to recognize is that if the brace rule is vacated completely for a violation of the APA, it doesn't really matter what grounds it's vacated. If it's vacated nationwide, it's vacated nationwide, and the lawsuit in the Eighth Circuit and the District Court in North Dakota is no longer valid and no longer needs to move forward. And the Eighth Circuit agreed with frack and ruled against the ATF once again. The Eighth Circuit ruled that the stay of this case should be granted pending the Mock decision and pending what the Fifth Circuit says. In the order, the Eighth Circuit stated that in its motion, the plaintiffs explain why they believe a stay is appropriate. First, they contend ATF does not dispute that the federal district court in Texas has entered an order that vacates the rule nationwide. Second, they argue that the ATF does not dispute that the district court's vacatur order operates on the status of agency action and thus is not party restricted and affects persons in all jurisdictions equally. Thus, the ATF agrees that if the Fifth Circuit sides with the federal district court on the merits, the default remedy is vacatur, such that there will be no rule left for the plaintiffs to challenge. Basic principles of judicial economy, efficiency, and common sense strongly favor a stay pending the Fifth Circuit's decision on the vacatur. Therefore, it was granted in favor of the plaintiffs, and the case is stayed and is going to be tied essentially with what happens in Mock versus Garland out of the Fifth Circuit. So that's another big loss for the ATF. What will likely happen now is that the ATF, if they lose again in the Fifth Circuit in that Mock appeal, that will make another big domino fall in favor of us, the Pro 2A side, and that would happen in the jurisdiction of the Eighth Circuit. That would happen in this district court frack case, because these two cases in some ways are now tied together. That would lead to a big 1-2 punch where you would get a win in the Fifth Circuit, the nationwide vacatur is upheld, it's blocked nationwide, and then this lawsuit sitting over here in North Dakota would reaffirm that the ATF has lost, the case would get dismissed, and the ATF would lose once again. Now, overall, the good news is that the nationwide block of the rule is still in place, and in this frack case, the ATF admits that yes, the pistol brace rule is vacated and blocked nationwide as of right now. So as things develop, as things change, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.